and I should say district judges, and here limited to those with criminal cases, which is B. Shall we start? Is Mr. Fuel here and Miss Hayes?
Yes, ma'am.
Okay. Are we on YouTube? Oh, sorry. Good morning. This is Judge Elisa Perez presiding over the 210th District Court Civil Docket for October 1st, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call it. This is cause number 2021 DCB 1635. Gerardo Garcia and Columbarium by Design LLC versus Fernie R. Aceves. May I have announcements, please?
Good morning, Your Honor. Vianney Martinez filling in for Jimmy Fuel on behalf of the plaintiffs.
Good morning.
Good morning, Your Honor. Lisa Hayes for the defendant.
All righty. And so this is one that we passed up reluctantly. The court, you all asked for a pass by agreement in July. So what is going on here? Because I have a little notice and I'm a little notation here that we need a trial date again.
We need a trial date. That's right.
Here's what we're going to do. Do we still have a referral docket, Ms. Myrna? Do we still have, I don't know if Judge Alcala now is overbooked.
It still does exist, Judge.
Okay. Yeah, and Judge Burrell is also available still?
I'm not sure about Judge Burrell.
Okay, we're going to start there. I'm going to move this. Yeah, because of that delay. I mean, I think the court had made all the arrangements for you all to go to trial. In fact, by going, I think double trial. You all were going to go at the same time as another case. And then at your request, we pulled it off that trial docket. So the referral dockets are there for cases that are hard to schedule. I don't know that I can get you scheduled before the end of the year. And this is a very old case. So what happened since July?
Mediation failed, and we just need a trial date. I'll tell you, well, Jimmy wanted me to tell the court that he's not even available for this fall, so any trial date, even next year, would work.
Yeah, but I'm going to let you work that out we're going to refer this to Judge Burrell on the referral docket. So you will be dealing with the referral court for scheduling going forward.
Okay.
Thank you.
Thank you, Your Honor.
Who's next?
Judge next. Judge next I have on page 1, calling cause number 2025 DCB 0272, American Express National Bank versus Luis Beltran et al. Announcements, please.
Good morning, Your Honor. John Kettler for plaintiff.
All right. Anyone here on behalf of Luis Beltran? Anyone in the waiting room, Mr. Munoz?
No, ma'am.
All right. We are set for a default hearing. Defendant has failed to appear today. I see the motion was filed on May 15th. Was it Mr. Kettler? You may proceed.
Yes, Judge. This is a lawsuit arising from a debt claim. After a period of non-payment, the defendant, who had been issued a line of credit by American Express, had defaulted on his obligation, and at that point, the account had been charged off. Subsequently, plaintiff is pursuing this lawsuit and has filed plaintiff's motion for default judgment in pursuit of the relief thereof. We respectfully request the court take judicial notice of all documents that should be in its file, reflecting, including but not limited to, good service within the prerequisite period of time. Plaintiff's motion for default judgment containing the following contents: a certificate of last known mailing address as required by law, an affidavit attesting to both the ownership as well as the activity on the account, as well as damages. That affidavit should include 2 exhibits in substance. The first is the underlying terms and conditions, and Exhibit A to that affidavit, and Exhibit B being the final 2 account statements, including the all-important charge-off statement that reflects the balance being sought. And then finally, as part of plaintiff's motion for default judgment is, again, as required by law, the non-military declaration. And attached to 2 is a printout of the Department of Defense Manpower Data Center printout showing that the defendant was not in active military at the time that uphold. And Your Honor, if everything has been satisfied and we've met our burden for today's plaintiff's motion for default judgment, we respectfully request liquidated damages in the amount of $61,764.26 reflected in that charge off. That's 61764.26 plus costs of court. However, plaintiff does not seek any attorney's fees and respectfully requests to waive its right to collect post-judgment interest itemized at zero.
All right, thank you very much, Mr. Kettler. The court will take judicial notice of all the documents in the court's file. Also admit for purposes of this hearing, all exhibits attached to your motion. Your motion is granted. Would you please provide the court with the proposed default judgment? Email it to Mr. Hernandez and we'll sign off on it.
All right, will do, Judge. Thank you so much.
Bye-bye. Who's next?
Judge, page 1, calling cause number 2024 DCV 2991, Byte Dreams Group LLC versus EBT Real Estate Inc. Announcements, please.
Robert Fuel here for the original plaintiff, Your Honor, and now there, also some of the cross defendants. All of the actually.
Morning.
Yes, Your Honor, this is Austin Jones of McGinnis Lockridge on behalf of a non-party and a proposed cross-defendant Lumen.
How's it going? Well,
And may it please the court, this is Jim Scher. I'm actually in my file room because I was off on an hour. And we have Michael Shane on the call as well. We're here on behalf of EPT. That's the cross plaintiff in this case. And we have a motion and we have some items to address with you.
Your Honor, Michael Cabot on behalf of the non-party Lumen as well.
All right, is that everyone? Okay. And we do have scheduled today, well, we have two things. We have a scheduling status conference, but obviously we have the Mr. Scher, Mr. Shane, I believe your motion for leave to file a cross claim, is that right? And
Yes, Your Honor.
response in opposition filed a couple of days ago. Mr. Scher or Mr. Shane, who is going to take it?
May it please the court, I will.
Yes, sir.
Okay, first, in terms of the underlying case, let me give you some update on that. Mr. Fuel and Mr. Shane and I have all been working on getting some discovery that's owed to us by Mr. Fuel's clients. And we've been very gracious and fair with Mr. Fuel in allowing that discovery. He's had some issues that have caused him delay in getting that. And I hope that he will get that to us immediately since he's on the call. And we're trying to do that without the need to file motions to compel on it. We're not ready for trial on the case. And both parties have talked and agreed to pass the trial so we can get some discovery. We're still waiting for that paper discovery that hadn't been finished. So that brings us back to the motion. You heard a previous, so that's the second item I want to cover with you, which is our motion for leave to add Lumen as a defendant in the cross claim that we filed. We anticipate eventually that DPT will the case will be realigned and that EPT will be the named plaintiff in the case. There's special exceptions, by the way, outstanding on Webitron to ask them if they still have any claims left. They filed it originally only as a restraining order, and that was resolved quite a while back. Now it's a positive claim being made against Webitron, Byte Dreams. And the background on it is that Webitron was a tenant in EPT's building. Webitron contracted with Byte Dreams to sell their business. When that came about, it was discovered that Webitron and Lumen, who they were in contract with, had usurped the electricity of the building. What they did is Lumen, without any permission, or consent, and Webitron. This is the allegations. They are going to deny it, but and that's the basis of the cross claim, which is pending. That Webitron and Lumen hooked into the EPT's main power, and that they were using the power and the electricity being paid for by EPT for their own business purposes, which not right, not in any way, shape, or form is the allegation that EPT has raised. So EPT has sued Webitron for that taking without consent of the electricity that was being paid for by EPT. As the case developed, it was learned that Lumen provided some computer system, some IT that EPT that Webitron had antennas on the roof. They would take that signal that they were providing for an internet service, and it was processed through Lumen. Lumen being like Spectrum or AT&T, were out there processing that and providing service directly to Webitron, charging them fees. And it was determined that Lumen had on one of the floors of the building in a mechanical room had actually tapped in to the 220 or to the electric line of EPT. So for a long time, without the knowledge of EPT that owned this high-rise tower on the east side of town, Lumen and Webitron together were using EPT's electricity. So we had filed directly, just added Lumen as a defendant, and they complained about it to you, and you dismissed the cross claim made by EPT month before last on this, or quite a while, a couple months ago, and the basis on that they had it dismissed was failing to come and request leave of the court to allow the filing of the cross claim being made by a cross plaintiff rather than a named plaintiff. Well, eventually EPT will be a named plaintiff in this lawsuit. So our client will be there, but as present, they are still a cross claimant against Webitron and Byte Dreams, and are requesting leave from this court to now file a cross claim against Lumen, identical to what was previously filed, in order to add Lumen as a party and as a cross defendant in this case. So that's the only item that we have up on the agenda with you today, and we ask that you grant our motion for leave to add Lumen as a cross defendant. That's our request.
Thank you, Mr. Scher. Is it Mr. Jones or Mr. Cabot who's responding to this? I know there was an opposition response filed a few days ago.
Yes, Your Honor. This is Austin Jones on behalf of non-party Lumen. Just to provide some additional background, this was before the court back in September. At the time, EBT had filed a cross-claim and third-party petition against Lumen. It did not seek leave before attempting to serve the third-party petition and the citation on Lumen. And so upon receipt of that citation, Lumen filed a motion to quash, arguing that, one, they didn't seek leave of court as required under the rules, and two, the substance of their proposed third-party petition did not comply with the rules as well. The court granted that motion, our motion to quash, and it did a couple of things. That order did a couple of things that are relevant here. One, it ordered that EBT's claims against Lumen were dismissed without prejudice to the refiling in a separate cause. The order very clearly says those claims are dismissed. They can re-urge them, but it has to be in a separate cause, which is obviously not what is happening now. Second, that order provides that Lumen, a non-party, is relieved of any obligations to respond further to this matter, right? And yet here we are yet again. Turning to their motion itself, I note at the outset that it seeks leave to file an amended cross-claim. There's no proposed amended cross-claim attached anywhere to their motion. I've heard Mr. Scheer say now that I guess the intent is that it would be identical to what was previously filed, but that is not clear in the motion, as no proposed cross-claim was attached to the motion. So difficult to respond to the substance of the particular claims, but I think by the text of the order alone from this court that provides that these claims can be refiled in a separate cause, that is enough to deny the motion for leave. Separate and apart from that, as Mr. Scheer explained to the court, this is a landlord-tenant dispute about the use of electricity in a building, EPT's building. The primary claims between the landlord and the tenant, of which Lumen is neither, are based on a breach of a lease agreement. I understand there may be some other tort claims pled as well, but the base claim is a breach of a lease agreement. Looking back to the proposed third amended petition that was filed several months ago, the claims against Lumen sound in tort alone, not contract. And you already have kind of a difference in the type of claims asserted. Even apart from that, a telecommunications utility, it has a statutory and regulatory right of access to a building upon request for service by a tenant. And this is set forth in the Texas Utilities Code as well as in the Administrative Code. It's part of the PURA comprehensive regulation that governs utilities in the state of Texas. And it provides that upon request, utility has the right of access and that they, have to work with the landlord, the building owner, to dictate the terms and use of that access, as well as any compensation that could be set for that access. In addition, those code provisions and those statutes contemplate that any disputes between the building owner and a utility can be submitted to the Public Utility Commission for resolution, right? I think the overarching principle is we want tenants to be able to choose who is providing their telecommunication service, and we want to provide maybe an expedited way to resolve those disputes to not interrupt that service. And so it sets forth that the Utilities Commission is an appropriate venue to challenge or to resolve disputes related to compensation. So even aside from the order in this case that says these claims have to be filed in a separate cause, even aside from the fact that there's not any proposed amended counter or cross claims attached to their motion, adding Lumen in at this stage, I think it's going to complicate any trial in this case, because on the one hand, a jury is going to have to resolve questions of contract interpretation. Did the landlord and tenant adhere to their contractual obligations? Did they not? At the same time, they'd have to, look through the statutes and figure out, is there a right of access? What are the terms of conditions of that access as set forth by the Utilities Code and related regulations? And I think you're going to, allowing Lumen to be added in is going to turn this trial into two trials in one, which I don't think would be particularly helpful for the jury. It'll confuse the jury. So for all those reasons, Your Honor, we would request that the court deny the motion for leave. And again, in compliance with the court's prior order, if EBT wants to re-urge these claims against Lumen, it can do so in a separate lawsuit.
All right, Mr. Sheriff, Mr. Shane, you have a response?
Yes, Your Honor. We have already dealt as an attorney with Lumen on this last issue that Mr. Jones raised. That is not a regulatory issue. An example is when somebody in cable television goes up and taps in illegally into the cable television and runs it into somebody's house to get free cable, that's not the issue of regulatory. That's an issue of basically stealing somebody else's services and a theft of service. Here in this case, the civil cause of action has been brought against Lumen for their violations of the property on which they have not sought nor had any authority to be on to have access, irrespective of whether they had the right or not. They didn't have any right to take EPT's electricity. That is not a matter covered by the Regulatory Commission. That is a matter covered by cause of action under civil law. The Regulatory Commission would address whether there's a cause of whether there's a license that was issued and whether that license was being denied. That was never requested. The licensure provisions under the statute, we've dealt with Lumen on that. They eventually came in and had a lease, and they agreed to comply with the requirements and to pay for their use of the premises and comply with the building's requirements. Then they terminated and got off the premises. So that's a different issue altogether, and that can be dealt with. If they think they have a legal basis, they can raise that after they're made a party to this case. If they think that theft of service, and I'm going to use that term because it's probably more easy to explain, that their theft of service is some right under the Regulatory Act. That's not the case. But that would be a question of law for you to address if they want to try and raise that. The circumstances and why they need to be a party with Webitron is because Webitron, who was a tenant and did have the right for access on the premises to this one little space they leased, then went beyond their lease and placed equipment of Lumen's inside a mechanical room and hooked straight into the electricity of the building. They did it for themselves, and they also did it which they had towers on the roofs. They were using electricity for that, and they were also using this processing center. It was a pretty big use of electricity on a monthly basis, month after month after month, without paying for that electricity. So we have the same parties, we have the same facts, we have the same issue that's going to be there, the same lawyers that'll be involved. It's important that they all be brought together in one case, rather than having Webitron saying, well, that's Lumen, not us, and Webitron and Lumen saying, well, that's Webitron, not Lumen, and then having two separate trials on exactly the same thing with the same parties. So in terms of presenting it to this court, we request that you grant us leave to bring Lumen into this case, and we can address with them, and you can hear the legal motions, because that's not an issue for you to be addressing today. Today's the only issue you're addressing is whether you should grant leave to add Lumen as a party. And we would request that you allow that to happen so we can move forward and have joint discovery with both parties. We need to find out how Lumen got to even tap into the electric of EPT, because it was only through Webitron. We're going to take depositions of Webitron, and they're going to say, well, that's Lumen. Well, we're going to need to take depositions of both parties, of both of these same defendants in the same case. And rather than doing them twice, we should just do them in one case and put them together. Makes no sense to have two separate lawsuits, and clearly that would be request to consolidate in many ways. So we would ask that you grant us leave to file.
Thank you, Mr.
Thank
Sheriff. Mr. Fuel, I'm just going to ask if you have any input.
Well, thank you, Your Honor. The only thing I don't really have a dog in the hunt of whether you want to let grant Mr. Scher's motion and join Lumen in this case. I just want the court to know that Mr. Scher's position is a bit off in asserting that somehow Webitron, I mean, he implies that Webitron and Lumen conspired somehow to take electricity from his building, and that's just not true. We requested service from Lumen, Lumen provided service, and that's it.
Yeah. Okay.
Your Honor, if I may, just at one brief point.
Yes, sir.
I've got a copy of their motion for leave to file amended cross-claim in front of me, and it starts out by saying they want to add Lumen to assert causes of action against said party, see Exhibit A, right, which you would think is the amended proposed counter cross-claims. There are none attached to their motion, right? So even if the court were inclined to grant the motion to allow them in, it is unclear what, if anything, we are responding to. There's no proposed cross claims for the court to consider or for Lumen to even respond to.
Right. Yeah. Okay. All
May
right.
I respond to that, Your Honor?
Sure.
They're not a party to this case. The arguments being made by Mr. Jones, who is not a party to this case, does not, they're making arguments where they're not even a party, and they're telling you, don't let him bring us in to be a party. Very clearly, once they are served with the petition, they can look at it and make those evaluations themselves. But we respectfully object to them arguing at this point, and their arguments being made as non-party. They haven't been served with anything for this hearing, other than notice that we were setting it.
Thank you, Mr. Scher, and thank you all for your arguments today. The court is respectfully declining to grant your request to have leave to file your amended cross-claim, so I will need an order on that. You all are also scheduled today for a scheduling status conference, which means I know we were, something was mentioned about a trial date. We do not have a trial date in this case, and that's why we're here today. So I don't know that I feel like we should have had a trial date before.
We did have a trial date before, Your Honor, and you vacated it at our request because of the
So we need to get one very soon. We need to get one very soon. And what that means is probably summer next year. So Ms. Hernandez, can I have the next available civil trial date in 2026?
Your Honor, June 12th, 2026.
Thank you. That'll be the trial date. We will have an entry of scheduling order hearing in 2 weeks for the agreed order to be entered. There will be obviously a mediation deadline. I'm kind of inclined to ask you all to mediate sooner than that, but I don't remember if you all have tried that yet.
We have not, Your Honor. I'm still, as Mr. Scher said at the beginning, I'm still trying to get certain discovery to him. We were seeking their depositions, and now they're seeking ours, and so it may be more productive after we've done some of the discovery.
We'll start with the basic order, which has you all, as everyone is, with a mediation deadline 1 day prior to the final civil pretrial. Anything outside of those dates, please request your hearing with Ms. Hernandez along with your filed pleading. In addition to that, have your agreed mediator listed on the order, please.
Thank you, Your Honor.
That gets us on track, and we'll go from there.
And will we receive your standard scheduling order?
We will send it. You all know, as long as everything that is on the order, if you all generate something independently, as long as everything that's on my order is on your order and agree to, go ahead and submit that, please.
Thank you.
Your Honor, can I ask a question?
Yes, sir.
All right. So we're going to, with you denying this, we're going to be filing a lawsuit directly against Lumen. So it'll be EPT versus Lumen. That's going to be going as a collateral lawsuit to this one. It probably, either one of us are going to probably ask to consolidate it. And so I'm trying to find out your thoughts, Mr. maybe it's asking for premature ruling, but these should be together in one case. And I'm trying to figure out, when we file this, would this be get to Lumen in your court, or would we assign a new court number under the docketing system, or how would you perceive that to be handled?
So certainly, from my perspective, we will cross that bridge if it gets here. I do not control how the cases get assigned to the courts. That would be through the district clerk. But if something gets set in my court, we'll set it for hearing.
Okay. Well, thank you, Your Honor.
Thank you very much. There's nothing further. I'm going to go ahead and adjourn the hearing because we have quite a few things to handle this morning. Appreciate your time.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. May we be excused?
You may have a good day.
Thank
All
you.
right, I see all of my summer family. I'm going to call you all my summer family is here. So Mr. Nanez, let's try and knock out a few of these that we can knock out quickly.
Yes, ma'am. Page 2, calling cause number 2024 DCV 1565, Sylvia Guadalupe Ugalde Madrid et al. Versus Flor Hernandez. Announcements, please.
Manny Morga for plaintiff, Your Honor.
Randy Gramling on behalf of the defendant, Your Honor.
Good morning, entry of judgment, counsel. How are we doing?
Judge, the minor, this is the one with the minor that was,
Why are we back already? Well, okay.
well,
We go past the birthday?
we are officially past the birthday, so I'm hoping Mr. Grambley can just issue the funds and we can get it off your docket, Your Honor.
Mr. Grambling?
I agree. If Manny could be so kind to send me the settlement draft instructions today, I'll request a check today.
Okay, so I'm gonna bring you back in 30 days. Thank you, gentlemen. Have a good one.
Appreciate it.
Thank you.
Mr.
Mr.
Grambling,
Grambling?
something else?
A friendly suit.
Friendly suit?
Yes,
Uh,
ma'am. On page 2, ending in 2087.
That's a status conference.
Mr. White said Mr. Grambling was covering that.
Sure, but it doesn't say that it's scheduled for a friendly suit. It says a status.
Oh, I'm sorry, Judge.
I'm here either way, Your Honor.
Okay, so I don't see, who's our ad litem?
Angela Carillon Beltran.
Is she here? Yeah, it's not set today for a friendly suit. This is cause number 2025 DCV 2087, Gabriel Gutierrez on behalf of minor child versus Melissa Aguilar. May I have announcements, please?
Randy Gramling on behalf of the defendant, Your Honor.
Anyone here on behalf of plaintiff? Mr. Grambling, if what I'm hearing from you is that, it's way past 9:15, is that this is ready to be set for a friendly suit, then we will set it in about 30 days. It was not scheduled for that today.
I think this hearing was set for 10 o'clock today, though, Your Honor.
Sure, yeah, I mentioned at the beginning is that the court has some newly legislatively mandated duties at 11 in the morning, so I bumped you all up to a little bit earlier so we can try and knock out before I have to go do my bond hearings. There was that change, but with that said, it wasn't scheduled today for a friendly suit. So we'll get the suit scheduled. Thank you, Mr. Grambly, for appearing.
Thank you, Your Honor.
Have a good day.
Bye-bye.
Who's next?
Judge, on page 2, calling cause number 2024 DCV 0332, Raul Avila versus PLS Checks Cashiers et al. Announcements, please.
Yeah, my name is Leo Vela. Good morning, Your Honor. I'm here for the plaintiff.
Good morning, Judge Felicia de Leon on behalf of the defendant.
Good morning, counsel. We have entry of scheduling order hearing. Was there an issue on the scheduling order?
No, Judge, I think maybe it was a mistake on the order. It was supposed to be an entry of judgment. This
Okay.
was reset. We had an entry of judgment, I believe, last month or a couple weeks ago. And we were just waiting for the release. And we're still in that position.
Still waiting? Still
Yes,
need 30 days?
Your Honor, Ms. De Leon is correct. To be completely honest, our plaintiff has flown the coop. We're having a little trouble finding them to go ahead and sign that release. At this time, we would just ask for an additional 30, 45 days, whatever Your Honor feels is fair, so we can track him down and get him to sign this release. I mean, that's the only thing that's pending.
Ms. De Leon, 30 days, are you okay with that?
Yes, Judge, that's fine.
We'll do 30 days. Thank you very much. You all are excused.
Thank you.
Thank you, Your Honor.
Is the expunction taken care of?
Yes, ma'am.
Who's next?
Judge, page 3, calling cause number 2025 DCV 09, correction, 0296, Norma Patricia Holguin versus Christopher De Santiago et al. Announcements, please.
Good morning, Your Honor. Jeffrey Borshaw for the plaintiff.
Morning.
Benjamin Hunt here for the defendant, Job Materials.
And is Miss Ibarra Williams on here as well? I thought I saw her log in.
She's on here.
I see her now. Uh-huh. Okay, good
Yes,
morning.
Your Honor.
everyone. Go ahead.
I'll just inform the court, Your Honor, we're relatively early in this case. We're doing our initial rounds of written discovery. I've discussed with Ms. Ibarra a couple issues related to our discovery and the necessity of a protective order to get some discovery responses in, and then we can move forward with getting depositions scheduled in this case. So at this point, I think if Your Honor is amenable to it, we can get a trial date set and a scheduling order in place to guide us through litigation.
That's what we're gonna do, Mr. Borshaw, and I don't mean to rush you. I just know I have a lot of things we're gonna have to handle this morning. I think I asked for a trial date earlier. It was a June trial date. Something's telling me that's way too soon for you all. So I'm thinking something at the end of 2026. So Ms. Hernandez, can we look at November of 2026?
I have November 6th, Judge.
Okay, counsel, is that reasonable?
I think that's appropriate.
Okay, so we'll
Yes, Your Honor.
circulate the scheduling order. Again, if there's anything outside of those dates that you need a hearing for something that's been filed, please send your file pleading and your request for hearing to Ms. Hernandez, to the court, so we can get you scheduled. But we'll just get the scheduling order in place in 2 weeks, have it turned in 2 weeks. Mr. Hunt, that's just standard protocol in case you didn't know. And we won't see you in 2 weeks. If we have a problem, then we'll see you. Okay?
All right.
Thank you, Your Honor.
Thank you very much.
you.
You all have a good day. Ms. Ibarra, you have something else?
I do.
Yes, ma'am. Page 4, Judge. Calling cause number 2025 DCV 0310, Ana Luz Zaragoza et al. Versus Simon Property Group et al. Announcements, please.
Mr. Chavez, you're muted.
Yeah, I'm mute.
And you look so excited. Now I really wish I wish I heard what you said.
Judge, for some reason we thought that this was an in-person hearing. So my associate and I, and Mr. Anderson, who's also on Zoom, he was smarter than both of us. He saw that it was on Zoom, but we trekked up the 9 flights of stairs and we're here.
What?
So yes.
Okay. Well, good morning, everyone. Did I
Good
get all
morning,
my
Your Honor.
announcements? So this
So
is, if you were
Enrique
listening-
Chavez for the plaintiff.
Thank you very much. If you were listening to the previous hearing, it's the same thing. I'm thinking either you get a June trial date or you get a November trial date. How does that sound?
Your Honor, I think a November trial date or even December would be better because I know I just heard that there's a November trial date. I don't think Ms. Ibarra can go back to back or on the same day.
Oh, don't
we would-
underestimate Miss Ibarra. Let me tell you.
I know she
We're
is
happy
formidable.
to give you December. Let me ask Ms. Hernandez, as long as I'm not missing anyone here. Am I missing anyone? Mr. Anderson, is everyone good with a December 2026 trial setting?
Yes, Your Honor. For
So,
the
Your Honor,
plaintiff-
just one thing for the court to be aware of. I don't have a problem setting it, but we have a criminal component to this case. It's a shooting case.
Okay.
And for our purposes, for the defense, we would need to know more about that criminal case and how it gets disposed of or not for the purposes of this case.
Okay.
So just as a FYI, I know that we're going to be sending out notices. It involved a minor. I'm not sure if he's still a minor or not. Once he turns 18, we can get more information, but just wanted to alert the court to that possible complication.
Understood. Understood. Thank you for that. Okay, well, we'll set you December 6th, you said, Myrna, or what was the date?
No, Your Honor, it's December 11th.
December 11th. So somebody bring the bizcochos for the trial if we're there.
Tamales and everything, Judge.
Oh, yeah, we had some of those last week. We're never short on tamales here. Thank you all so much. Just get
Thank
the
you, Your
schedule
Honor.
order entered and we'll just see how it goes from here until then.
Thank you, Marisa.
Your Honor.
I'll call you in a bit.
Perfect.
If you
Thanks.
don't have
Bye-bye.
anything else, y'all are excused. Have a good day.
Thank you,
Your
Honor.
Honor.
Bye-bye.
Thank you.
Let's go back. I thought we had one more default.
Yes, we also have Mr. Lopez here, and his case was already called on page 2.
Mr. Lopez, good morning, sir.
Good
That
morning, Your Honor.
was my understanding. Mr. Grambling was here, and my understanding is we just need the friendly suit. So,
Yes, we have it scheduled in for 15 minutes, 25 minutes here at 10:15.
okay, am I missing something on this docket?
No, ma'am, Judge, time was changed on that one.
Okay, but I continue to only see that it was set for a status conference and not a friendly suit. So I'm not sure if there was an issue on the scheduling, Mr. Lopez. My apologies if there was. It is not on my docket as a friendly suit. It is only as a status conference. So what I am doing is setting the friendly suit in 30 days.
Oh, okay, Your Honor. I have the order setting hearing from the court, and I checked with the court coordinator yesterday about it.
So, Mr. Hernandez, why is it not on the docket?
I'm checking, Judge.
Yeah. Yeah, I can't really answer that, Mr. Lopez. I apologize for that, but we will
Oh,
get it
man.
set.
No worries.
Do you have your folks here? Do you have your witnesses here?
He's ready to log in here when we have it set for, I think it was
We
set for
also didn't-
10:15.
Yeah, we also didn't have, well, yeah, and I don't know, maybe it just dropped off when we changed the time because the ad litem is also not here. But in any event, I apologize. We will get your friendly suit set in 30 days, okay?
Okay, no problem. Just let me know what the court has available and we'll make it work on our end.
We'll get it squared away as soon as possible. Let us know if what we set doesn't work for you. Have a good day, Mr. Lopez. Thank you very much.
Thank you. You too, Your Honor. Bye.
Okay, do we have anyone here on cause number ending 0246?
Yes, Mr. Cook, Judge.
Okay, Mr. Cook, calling cause number 2025 DCV 0246, LVNV Funding LLC versus Guadalupe Portillo. May I have announcements, please?
Yes, Judge, Desmond Cooks on behalf of LVNV Funding.
And anyone here on behalf of Guadalupe Portillo? Guadalupe Portillo, have we had any contact from this individual?
I have not, Judge.
Hearing nothing, Mr. Cooks, you may proceed.
Your Honor, this is a credit card case that was opened in June of 2022. I was subsequently charged off in the amount of $1,983.11. Plaintiff will be requesting a judgment in that amount of $1,983.11, plus court cost and post-judgment interest.
Status conference.
Mr. Cooks, on your motion for entry of default judgment, I do not see any attachments, anything to support your motion. So,
Yeah, all right. Judge, if we can that's been an issue
okay,
that
so
they're
we're going
trying
to
to
reset you for
rectify.
30 days. We're going to set you
Thank
for
you.
30 days. Thank you very
Thank you.
much.
May I be
Okay.
excused?
Yes, sir.
All right.
All right. Does that leave my Cabral case, or is there something else?
That's all that's left, Judge.
Okay. Can you all bear with me 2 minutes so we can get started?
Absolutely, Judge.
Hi,
Absolutely.
good to see
Leave granted.
everybody.
Leave granted.
You need to come sit over here, Mr. Rincon.
Yeah.
You need to come sit over here. Bear with me 2 seconds. I'll be right with you.
All right. Good to see everybody.
All right, everyone, let's get started. All right, everyone here. Hi, Mr. Benra, Mr. Kathy. All
Hello,
right.
how you doing? Long time no see.
I know. Good to see you all. All right, calling cause number 2022 DCB 0886 Eduardo Cabral et al. Versus RV Share LLC Landstar Ranger Inc. May I have announcements, please?
Of course. Nick Bruno, and I believe Kevin Lyles, Brendan Villanueva, on behalf of the plaintiffs.
Carlos Rincon and Brian Cathy here for Landstar.
Is that everyone? Okay.
Connor Allen for My Universe and Kush Pulsing.
Okay. Alrighty, so we are set today. Let me get there. We are set today. Motions hearing. I have, let me see. I have defendant Landstar Ranger Inc.'s motion for entry of a take nothing judgment. I have plaintiff's motion for rendition of judgment. I have plaintiff's response and defendant's response. So we are going to start in, I guess, time order. Mr. Rincon, are you arguing this?
It would be Mr. Cathy.
Mr. Kathy, you may proceed. And I understand, I feel like we're going to overlap, but
No,
let's get
I
started.
agree, and I will
Mr.
try
Kathy.
to address the issues together to avoid that overlap.
Yes, sir. Go ahead.
So, Your Honor, we have requested entry of a take nothing judgment, and I think relevant to this is the court needs to, the court already knows, but I would reemphasize the distinction between actual conflicting jury findings that can't be reconciled and reconcilable jury findings. The case law says that the court has an obligation to reconcile jury findings to enter judgment to the extent at all possible. And so in this case, we have issues of reconcilable jury findings. I mean, the easiest way to analogize it would be if you separately submitted whether somebody breached a duty of care and whether somebody proximately caused an accident. Even if the jury returned a yes answer, they breached a duty, and they answered no, there was no proximate cause, you'd still need to enter a take nothing judgment because one of the elements of the negligence claim was negated by the jury's findings. And I think that, well, that is the case that we find ourselves in here. And if I may share my screen, I have a few slides that will kind of just walk through to hopefully synthesize this and speed up the discussion a little bit. But as the court will recall, in answer to question 1, the jury was asked whether Landstar acted as the motor carrier or the broker. The jury answered that we were the broker in this case. And the effect of that finding is twofold. One, it renders the other answers the jury returned immaterial because a motor carrier finding was a prerequisite or an element of all of the subsequent claims that were submitted. And separately, it establishes F4A preemption. And so I'll kind of walk through a little bit more in detail as to how those apply to each specific answer. But when you turn to question 2, for instance, that asked whether Mr. Singh was a statutory employee of Landstar. Specifically, it's submitted what the plaintiffs have characterized as a responsibility and control theory under a specific regulation. When you look at that regulation and the case law interpreting it, the very first element that needs to be met in order to establish that type of theory is the entity needs to be a motor carrier and not a broker in the transaction. And so in this case, the jury already found us to be a broker, so there's no potential basis for liability under the jury's answer to question 2. Similarly, the same result applies to question 3. This separately submitted a slightly different statutory employment theory that was tied to a regulatory definition of employer. But again, the regulation appears in the section of the Federal Motor Carrier Safety Regulations concerning motor carriers. And all of the case law interpreting it makes clear that that definition only applies if the antecedent, status of the defendant being a motor carrier is satisfied. But in this case, the jury said we weren't. So question 2 also can't furnish a basis for any judgment against Landstar. And then similarly with respect to question 5, this was the extreme caution regulation as the court that requires driver
Kathy, let me just,
traction is affected.
Mr. Kathy.
The hook for this, yes, Your
Hold
Honor.
on. Yeah, we're getting some kind of delay, so I'm getting a few little breaks in your audio and your video. I don't know if I've missed anything that's going to affect what I'm understanding you, but in the event, I don't know if you're getting some kind of notice that your internet is slow or something, but it's breaking up. And
I did just get that.
Okay.
Yeah, I did just get that. And if it continues, Your Honor, I will try and log in via a different
if you can do that quickly,
Wi-Fi
because
network, I apologize.
As you're explaining to me, it's happening. So I'm going to ask you if you can do that quickly. And we'll wait. We'll wait. I just don't want to have a bad connection.
Yes, Your Honor. Let me try and do that. I apologize.
No worries. Mm-mm.
All right, Judge, am I back?
I hear you. I hear you.
Okay, perfect. All right. Well, hopefully this will work a little bit better. I switched to a different network. And so to return to question 5, this is the non-delegable duty theory that was articulated by the plaintiffs for violation of the extreme caution regulation. Similar to the other regulations, the theory is slightly different, but like the other 2 regulations, this theory requires motor carrier status. And so when you actually look at kind of the way the plaintiff's theory broke down was the driver violated this duty and the motor carrier owes an obligation to ensure their drivers comply with all of the applicable duties. And so to the extent this furnished any basis for liability, it also required a predicate finding as to motor carrier status. Based off the jury's answer in question 1, we're the broker, so there's no basis for a non-delegable duty under this theory. So you can't rely on answers 2, 3, or 5, and that only leaves the answer to question 4. And that question was the negligence question that was submitted. And as the court will recall, it specifically limited the jury's consideration only to a claim for negligent selection of a broker, or excuse me, of the motor carrier My Universe. But based off of the jury's finding that we acted as a broker, that claim is preempted under F4A. I've highlighted on the screen the particular statute that's at issue, but that statute preempts any claim related to the services of a broker. And the courts, all of the intermediate appellate courts across the country that have addressed it have said that these type of negligent selection claims are preempted. And I've also highlighted at least 3 or 4 recent federal district court cases across Texas that have similarly applied F4A preemption to negligent selection claims by a broker. And so there's no basis for entry of an adverse judgment against Landstar based off of the jury's broker finding. All of the prior findings are preempted or are either immaterial or preempted based off of the jury's broker finding. And so for that reason, Your Honor, we've respectfully requested entry of a take-nothing judgment. We think that that's the required result based off of the jury's proper finding that we acted as a broker. And then to kind of dovetail with what the plaintiff's motion, to try and expedite this as much as possible, Your Honor, their proposed judgment is for 100% of the damages found by the jury, plus a little enhancement. And under no circumstance can the court possibly enter that judgment. The appropriate result, just to make our position clear, is entry of a take-nothing judgment based off of the jury's broker finding. But even if the court overrules that or thinks that there should be some other potential judgment that should be entered, There's just no circumstance in which Landstar can be held 100% responsible in this case. And so that brings us to the jury's apportionment question or responses in question 6. The jury apportioned 15% responsibility to Landstar in this case. Under the plain text of Chapter 33, a defendant can only be responsible for their percentage of responsibility. So at most, Landstar could be responsible for 15% of the damages that were found by the jury. Again, we think the jury's broker finding renders all the other findings immaterial or preempts them. Therefore, there should be no judgment entered against Landstar, but under no circumstances can the court possibly enter the plaintiff's proposed judgment in this case. And so I'm happy to answer any questions, but I've tried to kind of articulate as clearly and concisely as I can the proper analysis for the court to follow, and we respectfully ask that the court enter a take-nothing judgment.
Thank you, Mr. Cathy. May I have a response, please? Mr. Bruno, you're muted.
My apologies, Your Honor. Just like Mr. Cathy did, I will respond to his arguments in conjunction with making our argument for the affirmative relief we request, because it largely overlaps. In other words, plaintiffs are asking for a judgment based upon the jury's verdict. And I'll talk about the 4 separate paths to liability. There's only one path in which question 1 is material. The defendants just flatly overstate the impact of question number 1. As you will recall from the extensive directed verdict, briefing, and hearing, as well as the charge conference, we discussed the Morales case, which was an exemplar but not the only one, that established that, quote, there are 2 theories of statutory employment. One derives from section 390.5. The other derives from the responsibility control regulations. I'll end the quote there. Questions 1 and 2 submitted the control regulations theory to the jury. It's under section 374 of the federal regulations. Question 3 is the first path to liability. It is a standalone motor carrier status section of the federal motor carrier safety regulations. That section has its own definitions of statutory employer and motor carrier. And those were the definitions that the court submitted to the jury in question number 3. In other words, question 3, as we articulated to Your Honor at the charge conference, its directed verdict was a standalone theory. So the jury's finding in question 3 independently establishes Landstar's liability under a section 390 motor carrier employment status. I'll just very briefly walk through the regulations, but I'm not going to dwell on that because we had that extensive argument for you already. 390.5 defines employer to mean any person engaged in the operation of a commercial motor vehicle as submitted in question 3. It further defines motor carrier as including an employer. That's precisely what we submitted in question number 3. Question 1 had a different definition of motor carrier versus broker, which applied to the control regulations theory, but that's not impacted for the purposes of question 3. Question 3 is the 390 status. That's a standalone question on a standalone liability theory. 390.11 then imposes upon the motor carrier the obligation to ensure that its drivers comply with the federal motor carrier status. That's the basis for that theory. In a nutshell, question 3 submitted a separate liability theory that was independent from questions 1 and 2. Question 1 is not relevant. I'll note, if the court has any question about that, Mr. Cathy began his argument with the proposition that the courts have a duty to harmonize the findings if at all possible. So if there's a question about the impact of question 1 on the 390, that requires judgment based on question 3. Yeah, that's one separate path to liability. But there's more. The second path is the negligent selection theory in question 4. Regardless of whether you find that, question 1, the Landstar owed a duty to responsibly select its independent contractor, its driver. We had this debate at the charge conference about whether such a cause of action exists. We cited to you the Duran case from El Paso, as well as others, that establishes the viability of this legal theory. The jury found in our favor. You heard both, I believe, at the summary judgment stage, you heard at the pretrial conference, you heard at the directed verdict stage, charge conference, the argument about preemption. And it staggers me that the defendants continue to represent that all of the courts have adopted their preemption theory. That's simply not true. As you heard, the Ninth Circuit has disagreed. Very shortly before this trial, the Sixth Circuit disagreed with the defendant's position. And the district court decisions that the defendants have cited are the minority position. The preemption theory is highly controversial. You heard all the arguments and declined to adopt that theory. The case law has continued to be the same, that these types of negligent selection claims don't fall under the preemption statute at all. And even if they do, there is the safety exception to that statute, to that preemption provision that courts repeatedly hold that these types of claims fall under. So again, we are retreading the ground here. I don't want to belabor the point, but the preemption ground is a new development that the defendants are trying to make in the law. They can make those arguments on appeal. They made them to this court already, preserve that issue. But question number 4, regardless of motor carrier or broker status, entitles us to a judgment. Question number 5 is the non-delegable duty question. Again, Texas law is clear that a motor carrier owns a non-delegable duty with respect to its drivers. Question 5 is yet another example of an independent liability theory that establishes liability on the part of Landstar. So in our motion, we moved for rendition of judgment upon the jury's verdict, those 3 separate liability theories that I already articulated. We also moved for a JNOV on the ground of disregarding question 1. You do not have to grant a JNOV to grant judgment based on the theories that I already discussed. If the court, but the basis for the JNOV is what we previewed to you at the direct verdict stage, that based upon the Landstar corporate representative's testimony, as well as the documentary evidence, we conclusively established motor carrier status as to Landstar under the control regulations. Recall the other motor carrier theory that the case law recognizes. You sat through the trial and heard the corporate representative's testimony. You saw the contract documents. You saw the charts that were made as demonstratives at trial. You heard me walk through all of that evidence at the directed verdict stage. You saw our directed verdict motion where we cited and block quoted the relevant testimony from the corporate representative and from the contracts. The reality is the court knows the jury struggled. There was a compromise verdict. There is no basis for question 1. So the fourth path to liability requires the court to grant a JNOV, disregard the jury's answer to question 1, and find that we conclusively establish motor carrier status. Again, doesn't matter for the first 3 theories I articulated. It only does to the control regulations there, to the 4th. Let me be clear. I'm asking for a JNOV on that substantive reason, but I would be remiss without pointing out the practical consequences of the ruling. I understand an inclination to simply render judgment based on the jury verdict. In this case, the only circumstance where it matters whether this court grants a JNOV or simply grants us judgment on the verdict is if we go to the appellate courts. The result is the same. Standards of review are going to be the same. There is no difference, except that from a procedural standpoint, if you deny a JNOV, that means should the defendants appeal, the plaintiffs would have to cross appeal to raise the JNOV point. That's going to result in cross appeals at the El Paso Court of Appeals. We have 2 separate sets of briefing going back and forth. It would just be simpler as a practical matter to have all the rulings in favor of the judgment. That way, there's 1 set of briefing. Again, nobody's going to be prejudiced by this. It just simplifies the process. Again, to be clear, that's not the basis for a JNOV. The basis is we are substantively right about the issues. There are practical reasons, however, to grant JNOV. The second wrinkle with regards to the judgment formation is the damages question. The last one will be the Chapter 33 question. On damages, we ask the court to render judgment based on the damages that the jury awarded, with 1 exception. That's the past medical damages. And the reason for that really arises from the El Paso Court of Appeals decision in the Porter v. Newman case that we cited in our briefing. In this case, in the Porter case, you had a situation where one of the plaintiffs had uncontroverted past medical damages of actually only $318.70, a minuscule amount. But nobody attacked those past medical damages via cross-examination versus some counter witness via attorney argument. It was the $318.70 was uncontroverted. Despite it being only a few $100s, the El Paso Court of Appeals held that it was reversible error for the trial court not to award that uncontroverted number of medical damages. That is precisely the situation that we are in this case. We presented uncontroverted billing affidavits of past medical damages. Those were not attacked via cross-examination. They were not attacked with other controverting affidavits or witnesses. Was not attacked in closing via attorney argument. In fact, we cited the parts of closing argument from the defendants in our briefing, where the defendants said if the jury is to reach damages, ask the jury to adopt the number of past medical damages that we proposed in our evidence. The jury just arbitrarily slashed that number by $1 million, apparently reaching a compromise verdict. That is precisely what Porter has said, the El Paso Court of Appeals has said is not permissible. If it's reversible error to do that when a jury ignores $300 in cents of damages, it surely is reversible error for an arbitrary $1 million cut past medical damages. So that's the past medical damages issue. I'll just point out that the $2,193,000 number that we have in our briefing is the correct one. There is one table in which a $4,000 number somehow wasn't added when Word automatically calculated the number. I just want to point out the 193 number is the correct one. The defendants in their briefing tellingly don't touch on Porter at all. Wholly ignore the Porter decision. On pages 11 and 12 of their response, they cite a case out of Corpus Christi, the Espinoza case. What's interesting is that case actually supports our proposition and involves a wholly different record. In that record, the court detailed at great length that there was, quote, a range of expense evidence provided as to past medical damages. The court dropped a footnote 4 in that opinion, and said this is different. This is distinguishable from cases that involved undisputed evidence of medical bills, where medical bills weren't controversial. So you have, if we were in a situation like Espinoza, where the defendants had put on witnesses to cross-examine our witnesses regarding medical expenses, that's the Espinoza case. We wouldn't be moving for J&OB on past medical damages. But the Porter decision controls. This is exactly like Porter. There has been no controversion of our past medical damages. The final issue is the one Mr. Cathy ended his argument with, which is how to account for Chapter 33. The general rule in Texas that the Kunkel decision from the Austin Court of Appeals, which we cited, which traces back a lot of the authorities on this issue, is that when a court is rendering a judgment with Chapter 33, the court not only considers the jury's proportionate liability findings as to the defendant itself, but also for any party for whom the defendant is vicariously liable. And then, of course, if those two numbers added up are over 50%, that results in the defendant, in this case Landstar, having 100% liability. So that is, no matter how the court rules, that Landstar is over 50%. Under any of the theories liability theories I discussed earlier, you would add Landstar's 15% to Mr. Singh's 50%. They are well over the 50% threshold to be liable for the entire amount of the judgment. You heard the argument from the defendants today that you don't add the vicarious liability. Mr. Cathy did not cite any authority in his argument. He does cite two cases in his briefing on page 10. And I was astounded to see these cases cited because they hold the exact opposite of Mr. Cathy's argument. The North American Van Lines v. Emmons decision had a similar situation. It said, quote, Cartnega, a driver, was in the course, or excuse me, an employer was in the course and scope of its employment for Lufkin Living. So Lufkin Living Moving is therefore vicariously liable for his 5% negligence in addition to its own direct liability. Now, in that case, the employer defendant was only 40% liable, so the 40 plus 5% didn't get over the 50% threshold. But this decision supports exactly the argument and provides exactly the analysis that we just made. You add Landstar's negligence to Mr. Singh's negligence, for which it's vicariously liable. So again, the first decision defendant cite supports exactly what I'm telling you. The only other decision they cite is the Dow v. Garcia decision from Dallas. Again, it's the exact same thing. The court said that there was, quote, sufficient evidence supporting the jury's finding that appellant negligently entrusted her car to Schreiber Parks. Because the jury allocated 85% causation to Parks, the 85% of responsibility the jury assessed to Parks was passed on to the appellant, end quote. And that's for page 629 of that decision. In other words, even under the authorities that the defendant cited, it's a straightforward application of Chapter 33. You take Landstar's 15%, you add it to driver's 50%, well over 50% joint and several liability for the entire damages award. So to summarize, we've submitted a proposed proposed judgment that renders judgment along the lines that I just argued to you today. The three liability theories that independently support a judgment regardless of a JNOV ruling to disregard question 1 for the only theory for which it matters, the control regulation theory, as well as the past medical damages with the uncontroverted evidence of past medical and the Chapter 33 ruling in the way that I just presented to you. We respectfully ask that the court render that judgment.
All right, Mr. Kathy, who do you have?
Yes, Your Honor. I would like to return to the paths that have been articulated by the plaintiffs in this case. It was quite telling that Mr. Bruno said for his first path, and then what he identified as his third path, he referred to specific regulations, and he expressly noted those regulations applied to whom? To motor carriers. So for instance, path 1 on question 3, he cited section 390.5 and 390.11, and he said that those apply to motor carriers. So he's conceded that a motor carrier finding is a required prerequisite to that theory. Similarly, with respect to question 5, he specifically noted that the motor carrier owes non-delegable duties to ensure that the driver complies with the extreme caution regulation. So we have concessions on the record that motor carrier status is a required prerequisite under those paths. The jury specifically said that Landstar was not the motor carrier in this case. And so, the plaintiff therefore is left kind of grasping at straws. And so they say, well, Judge, you probably should render a JNOV on the broker finding because, that does actually kind of dispose of this entire case and entitles Landstar to rendition of judgment in their favor. But they have not articulated any basis why the court would reverse itself on directed verdict. The JNOV standard and the directed verdict standard are the same. The court can only grant a JNOV if it would have been appropriate to grant a directed verdict. The court expressly denied the directed verdict motion. There's been no additional or new evidence or new developments in the case law that would support entry of a JNOV to disregard the jury's broker finding. I mean, that would also assume that the parties proceeded throughout an entire trial dedicated virtually exclusively to the broker issue or largely to the broker issue for absolutely no reason. So the court can't indulge that path of the JNOV. And I understand, Mr. Bruno articulated what he deems as, prudential or practical grounds for a JNOV, but the law doesn't allow courts to disregard jury verdicts just because they think it's practical and might simplify potential briefing on appeal. The legally correct result in this case is a rendition of judgment in our favor. To the extent the plaintiffs want to take that up on appeal, they could do that. It would not be wouldn't require 2 rounds of briefing, as Mr. Bruno articulated. And, to the extent the court wants the issues to be finally and formally resolved in connection with the entry of that take-nothing judgment, you could order the parties to mediation, and, potentially obviate that entire thing. So the practical implications that are addressed by the plaintiffs simply don't exist for rendering a JNOV. The jury's broker finding controls, it negates or renders immaterial all the other findings. And similarly, with respect to the express preemption, the Sixth and Ninth Circuit both agreed that the plain text of the F4A preempts negligent selection claims. I mean, Mr. Bruno is just skipping the entire first part of the opinions from those cases. And he's also ignoring all of the case law from federal district courts that have dismissed a lot of these claims, even at the motion to dismiss phase, finding preemption so clear. And so I think the preemption cases consistent with the broker finding support entry of a take-nothing judgment in this case. I'll briefly address the last 2 points that Mr. Bruno raised as well. The issue of damages. The plaintiffs relied almost exclusively on medical billing affidavits. Those affidavits aren't conclusive evidence. The statute says they may be some evidence. We've cited authority that says courts have the authority to award in a reasonable sum of damages consistent with the evidence. The affidavits themselves aren't conclusive, and the fact that the jury didn't necessarily award a sum that identically matches those is not a basis for upsetting the jury's finding or enhancing the damages. And lastly, with respect to Chapter 33, I mean, I think this is about as far afield as one can really get in this context. The jury allocated Landstar at most 15% responsibility, but the plaintiffs have kind of multiplied that and somehow arrive at 100% liability. But there's no predicate to add anybody else's liability to Landstar in this case. Mr. Bruno said, well, in certain instances, when a defendant is vicariously liable for another party who's named on the charge, that can be imputed to the defendant as a matter of law. But where is the findings that support a vicarious liability theory against Landstar in this case? We are found by the jury to be an independent broker who selected an arm's length motor carrier in a transaction. There's absolutely no basis for vicarious liability in this case. And I think it's most telling because the mathematics that the plaintiffs do omit my universe. So they want to add Landstar and Mr. Singh, but they missed the entire gap in between those 2 entities. We had no direct relationship at all with Mr. Singh. To the extent we had a relationship with anybody, it was a broker arrangement with his employer. So to the extent Mr. Singh's liability would be added to anybody's, it would be my universe's. But neither Mr. Singh's nor my universe's subsequently flows up to Landstar in this case. And so the notion that somehow Landstar could be jointly and severally liable for all of the damages in this case is absolutely inconsistent with the record, the jury's verdict, and the law. And the last point I would note on that, Your Honor, is there's not a single entity that was listed on the charge that is above 51%. The statute expressly says the only exception for joint several liability is the proportionate fault attributable to the defendant is greater than 50%. So you would have had to at least have one entity 51% responsible. You can't combine all of these different percentages that are less than 50% to aggregate to above 50% and then use that to jump to 100%, Your Honor. And so, it's an unprecedented leap that the plaintiffs are trying to make in this case to obtain a judgment that's completely unsupportable by anything. And so for those reasons, Your Honor, we respectfully ask that the court enter our proposed judgment for a take-nothing judgment.
Your Honor, I have 2 brief response points.
Yes, sir.
You just heard Landstar argue that it is unprecedented and unsupportable to enter a joint several liability for Landstar. But that is exactly what happened in the Dow decision that he cited in his briefing. The defendant was less than 50% responsible. The Court of Appeals said you add the 85% liability of the driver to the defendant, because of vicarious liability, they become jointly and severally liable. So it is absolutely false that this is not precedent. This is orthodox Chapter 33 law, as confirmed by the same authorities that the defendant cited in your briefing. I will note that the defendant cited no other authorities at this hearing for the argument you just heard. As to the motor carrier status, you heard the arguments. Defendants still have no response to the fact that Section 390 has a separate definition of motor carrier status that was submitted in question 3. Question 3 is an independent basis. I think we can end the analysis there.
All right, do I have anything else? Gentlemen, thank you very much for your time today. I, as always, appreciate your briefing and your arguments, but I have some work to do. And so with that, I will take your motions under advisement. I wouldn't anticipate more than a week if we're not in trial. We're hopefully not in trial this week, so I should be able to knock it out before the end of next week. If I find a need to ask for more argument, you all will get a hearing notice, but I think that's very unlikely. So what else are we set for today? Is that it?
I think that's it, Your Honor.
Okay. If you all don't have anything else for me, thank you very much for your time, and you'll hear from me soon.
Great to see you, Your Honor.
It's
Yeah,
so
good
good
to
to
see you
see
again,
you
Judge.
all. I don't want to be super excited, but I am.
I'll tell you, I miss El Paso.
Well,
El Paso's a
good.
pretty nice spot. So
Well, good. Come on
The
back.
food
I'll
was
tell
great.
you, my neighbor was having another truck case that was supposed to go a couple of weeks ago. I don't know if that was you, Mr. Rincon. No, it wasn't you, Mr. Rincon. And I was like, oh, they were looking for somebody to do jury selection. I was like, I want in. I want in. I want So anyway, appreciate you all very much. Thank you for your time. If you don't have anything else, we are adjourned.
Thank you, Judge. Bye-bye. Take care, everybody.
Bye-bye. Is there anyone else on here that we have outstanding? Everything was that case? Okay.
Yeah.
All right, we can go ahead and close it up. Thank you, Ms. Duran. I didn't see you much today.
No worries. Thank you,
Have a good
Judge.
day.
You too.